Good morning and welcome to the workshop on Insolvency and Bankruptcy Code. Today's subject is extremely current and relevant, and that was apparent from the fact that in less than half a day of us issuing a notice, this workshop was overbooked and we had to close the registrations. We have a very esteemed panel here today, Justice Dhanuka, Mr. Dwarkadas and Mr. Doctor, who have spared time on a Saturday morning to be with us, and we are really grateful to them for that. I request Mr. Sathe to make the opening remarks.
Justice Dhanuka, Mr. Dwarkadas, Mr. Doctor, my colleagues at the Standing Committee and friends. In last 3 years, we had started this endeavor of continuing legal education, and we have conducted over 12 workshops and 2 lectures on variety of subjects. And we have received overwhelming response. This morning, we have organized a workshop on a very current, topical and very interesting subject, Insolvency and Bankruptcy Code, because that subject is amalgam of some 7 topics, like what we are currently facing with goods and services tax, which has subsumed about 24 current levies. The Insolvency and Bankruptcy Code has elements from erstwhile and current Companies Act, Sikh Industrial Companies Act, Presidency Insolvency Act, Provincial Insolvency Act, Securitization Act, and Debt Recovery Act. So it's a very interesting, topical, and very usual subject for the practitioners, particularly in commercial litigation. As Dr. Saraf mentioned, the importance of this subject was evident from the fact that we had to close registration on the first day itself. We are grateful to Justice Dhanuka, despite his heavy workload and schedule, which all of us know, for having consented and agreed to be with us this morning. So also Mr. Dwarkadas for sparing his valuable Saturday for his non-legal activities. And Mr. Doctor, I didn't say illegal, I said non-legal activities. And of course, Mr. Doctor, for conceding to my request for being with us this evening, and we are all anxious to hear all of them on this very topical subject. Thank you.
Thank you, Dr. Sathe. May I now request Mr. Dwarkadas to give us an overview on the corporate insolvency and bankruptcy under the Insolvency Code, with particular focus on corporate insolvency, liquidation of companies, and bankruptcy and insolvency of individual and partnership firms. That's the second subject of today's topic.
Good morning, everybody. I'm overwhelmed by the overwhelming response that this Saturday has brought about amongst the members of the profession. And I'm glad to see so many young people here. I hope I'm able to shed some light on this new provision or new act which has been enacted, and it helps you. What I have done with the help of my 2 juniors, Swanand Ganu and Shilpi Jain, put together what kind of looks like a book, but it's just a paper. And because the subject is so vast, and already within a year, we've had quite a few decisions of the NCLT, the NCLAT, and the Supreme Court on some of the topics which arise for consideration out of the provisions of the code. I've tried to put them together for your benefit. So I hope this turns out to be a useful guide for those who wish to practice in this particular jurisdiction. Biren has been kind enough to have this printed overnight, and I think it's each one of you in your folders have a copy of this. To begin the topic of discussion, the code came into operation in December 2016, and the purpose for which it was enacted was basically to bring into one single umbrella, so to say, several statutory enactments which were there with regard to insolvency and bankruptcy, and recovery of debts. So you had, as you probably already know, you had the SICA, you had the RDDB Act, you had the SARFACI Act, you had the Companies Act, and you had different fora like the DRT, and you had BIFR, and you had the appellate authorities, and you had, of course, the high courts doing company law. So by reason of these different fora, different statutes, and there was a huge gap in that sense in people, either creditors being able to recover their amounts or debtors from, in that sense, being persecuted in different, under different jurisdictions and different statutes. Then the objects and reasons, one of the main reasons which has been given in the objects and reasons clause is this will improve the ease of doing business, because you will now have one central statute and one fora where you will approach for the purpose of bringing about a resolution of insolvency or bankruptcy, whether it applies to corporates or individuals or partnership firms or limited liability partnerships. So that is an important, one of the important reasons why this code came to be enacted. The code deals with basically resolution of insolvency either of corporates, limited liability partnerships, individuals, and partnership firms. In the innovative case, which is a recent judgment of the Supreme Court of Justice Nariman, Justice Nariman has dealt with not only the provisions with regard to proceedings initiated by financial creditors, which is one category of creditors who can invoke the provisions of the code, but even operational creditors. And what he has done for our benefit is to analyze in two judgments. One is the Kirusa case and the other is the innovative case, the entire background to the enactment of the code and its features, its advantages, its functions, and why this particular code is an improvement over all the other acts and statutes which were prevalent prior to this particular date. So for those who are interested in reading up more about the code, these are the two judgments, innovative and Kirusa. Now, as you know, prior to the code being enacted, one of the statutes which dealt with a possible resolution process or revival process was SICA. Now, SICA itself had several problems within it. The first of which was that it only applied to certain industrial companies. It was not an act available to every private limited company or every public limited company. It only applied to a certain category of scheduled industrial companies. The second was that it provided for a definition of sickness, which meant that if more than 50% of your net worth was eroded, you were mandatorily required to make a reference to the BIFR under the SICA. And immediately thereupon, as we all know, the moratorium provisions under Section 22 kicked in. But the Act, rather than helping the purpose for which it was enacted, came to be abused, because the lacunae in the Act was that the promoters could continue to remain in management of the industrial company which had become sick. So what used to happen typically was that they would file the reference before the BIFR, Section 22 would kick in, they would get a moratorium, the company would be under a moratorium, and the proceedings before the BIFR and the AIFR and thereafter to the High Court or Supreme Court would continue for years together. The creditors would be languishing and there would be no real revival plan. So these were some of the difficulties which SICA brought in and could not therefore address the concerns of bringing money back into the system by speedy recovery or by helping companies to revive if they could do so with a little help and a little moratorium. So the court therefore brought in has brought in a huge change. And now with the code coming in, you have a single window in that sense where either an operational creditor or a financial creditor or the corporate debtor itself can apply before the NCLT for what is called an insolvency resolution process. So these are the three entities that can go to the NCLT: operational creditors, financial creditors, or the corporate debtor itself. Some of the important definitions are to be found in the code because these are different from the pre-existing or prior statutes, and I have set them out for your benefit at page 6. I think some of the ones which are required to be looked at more closely are the definition of debt, which you will find at page 7, because this has given rise to a lot of interpretation or need for interpretation. Debt is defined to mean a liability or obligation in respect of a claim. Please mark the word claim, because the Supreme Court had to then interpret what that meant, which is due from any person and includes a financial debt and operational debt. And financial debt is defined to mean a debt along with interest, if any, which is disbursed against consideration. Now mark the words for time value of money. This is important because the introduction of the words time value of money would mean that a 0% interest loan would not qualify, since there is no time value of money in respect of such a debt. Then financial debt categorizes by an inclusive definition what would comprise a financial debt. The reason being because it is in respect of a financial debt that a financial creditor would be entitled to invoke the provisions of section 7. An operational debt is defined in 2E, and again there are some expressions or words which are used here which have had to come in for interpretation. Is defined to mean a claim. Again, it's a claim in respect of the provision of goods or services, including employment or a debt in respect of repayment of dues arising under any law for the time being in force to any statutory government or local authority. Then claim itself is defined to mean a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured. Mark the word disputed. Right to remedy for breach of contract or any law for the time being in force if such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured or unsecured. Now follow two important definitions which are the heart of the code. Financial creditor is defined to mean any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred, and an operational creditor is defined to mean a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So with these definitions, we can go straight away to page 9, which deals with the initiation of an insolvency resolution process by a financial creditor. Now, in the innovative case, the Supreme Court was dealing with a financial creditor, because that was an action initiated by a financial creditor. And section 7, which deals with the process initiated by a financial creditor, therefore came in for interpretation before the Supreme Court. And if I could read for your benefit what is quoted in paragraph 15 of the note, it kind of summarizes what a process of insolvency resolution by a financial creditor is all about. Para 28 of the judgment tells us, under section 7.2, and I'm quoting now, an application is to be made under subsection 1 in such form and manner as is prescribed, which takes us to the insolvency and bankruptcy so-and-so rule. Rule for application is made by a financial creditor in form 1 accompanied by documents and records required therein, and then there are requirements of the form itself. But if you turn over leaf, what I have highlighted is the timeline. Upon receipt of an application under subsection 2 of 7, the NCLT is required to within 14 days ascertain the existence of a default from the records of an information utility or on the basis of other evidence furnished by the financial creditor under subsection 3. Now this 14-day timeline looks very good on paper, and in a sense one can say may not be adhered to given the backlog of cases which NCLT itself has acquired over a period of time. But the Supreme Court has nevertheless said that these timelines are actually the essence of the code. And believe me, at least those who practice there would know that the NCLT tries its level best, as we have seen, to try and adhere to the 14-day rule. It may be few days here or there, but they do try to keep within the timelines. Then the Supreme Court then says, if you see para 60 in the quote there, the speed within which the adjudicating authority is to ascertain the existence of a default from the records of the information utility on the basis of evidence furnished is important. This it must do within 14 days of the receipt of the application. Now this is, as I said, a huge departure from what we used to see heretofore in the form of winding up petitions being filed and taking its own time even to come up for acceptance, thereafter for admission, and later for final hearing. Then in para 28 again, the Supreme Court gives a guidance as to what is to happen once an application is filed. And it says where the adjudicating authority is to be satisfied that a default has occurred, the corporate debtor is entitled to point out that a default has not occurred. So what is it that the NCLT will do when faced with a claim made by a financial creditor? It is only required to see whether or not a default has occurred, and on the other hand, whether the debtor is able to show that a default has not occurred, in the sense, mark the words, in the sense that the debt which may also include a disputed claim. This is a huge departure. A debt which may also include a disputed claim is not due. A debt may not be due if it is not payable in law or in fact. Now, please take it from me as a practicing lawyer who goes there regularly, and so do many of my friends here, that it is virtually impossible if a financial creditor were to file an application under the code to defend it, because the scope of default has been very, very narrowly construed and restricted to a default of the kind which the innovative case talks about. Then after the application is taken up within 14 days as required, and if it is found that there is no default, then the NCLT has to go ahead and admit the application, and if it finds that there is a default, it would reject the application. And what the NCLT has to see again has been summarized by me in para 21 for your benefit from para 30 of the innovative case. In the case of a corporate debtor who commits a default of a financial debt, the adjudicating authority has merely to see that records of the information utility or other evidence produced by the financial creditor to satisfy itself that a default has occurred. It is of no matter that the debt is disputed, so long as the debt is due, i.e. payable, unless interdicted by some law, or has not yet become due in the sense that it is payable at some future date. It is only when this is proved to the satisfaction of the adjudicating authority that the adjudicating authority may reject an application and not otherwise. The innovative case, as I mentioned to you, was a case filed by ICICI Bank in which the debtor said, how can a debt be due? I am a protected entity under a relief undertaking notification. So how can I be taken to task? Because the words are in law. If a debt is not due in law, so the debtor relied on the provisions of the Relief Undertaking Act. The Supreme Court turned it down by taking recourse to section 238 of the code, which has an overriding effect over all existing laws which are inconsistent with the provisions of the code. So to the extent of the fact that there may be a relief undertaking notification, which we often used to find in winding up proceedings coming to the rescue of the company, is now no longer available to debtors. And now if you see para 56, which has been quoted by me, the Supreme Court is emphasizing the timelines. Given the fact that the time frames within which the company is either to be put back, I'm on page 12, on its feet, or is to go into liquidation, this gives you an indication what is the purpose of the act, either to put the company back on its feet or to go into liquidation, is to take it into liquidation, is only 6 months. It is obvious that the period of 1 year or more of suspension of liability would completely unsettle the scheme of the code. So why? Because this relief undertaking notifications, as we have seen in the past, have a tendency to be continued and renewed and go on for years together. So Justice Nariman says that if on the one hand you have an act which says that 180 plus 90 days is all that is given to decide whether or not the company ought to be revived or wound up, you can't on the other hand wait for this relief undertaking notification to be set aside or to come to an end, which may take years together. And then on the next page you will find Justice Nariman referring to section 238 and saying this is the reason why this notification cannot come into aid. Then we come next to the operational creditor's right to move an insolvency resolution application. And operational creditor also, the entire procedure has been laid down, which I may just summarize by saying that the first step is to deliver what is called a demand notice. Then within 10 days of a demand notice being sent, similar to your statutory notice under 434 where you had 21 days, here it is 10 days, the debtor must reply and show that there is an existence of a dispute. And dispute has to be a pre-existing dispute, says Justice Nariman in the case which he was dealing with, which is the Kirusa case. I have referred to that in paragraph 28. And if no payment or no existence of a dispute, then the application will be taken up and would be admitted, and an insolvency resolution process would be triggered. So that is the process, basically, just to distinguish it from the past. Notice followed by 10 days, time given to the debtor to respond. He must show an existence of a dispute. The dispute must be pre-existing, and if it is found not to be a pre-existing dispute, the matter will proceed, petition would be admitted, and an insolvency resolution professional be appointed. Now, there are some words which are used in section 82A, which came in for interpretation, which I'll come to in a moment, because existence of a dispute was coupled with a conjunctive and to say that there is either a suit or an arbitration proceeding pending. So the question which arose before the Supreme Court was, does it mean that there is an existence of a dispute only if that dispute is pending in a suit or an arbitration proceeding? So we'll come to that in a moment. Then the question arose recently before the NCLAT, when you talk of a notice to be given, who has to give a notice? So the NCLAT says in smart timing steel that even a notice has to be construed strictly. It can't be given by a lawyer or a firm of advocates unless that lawyer or firm of advocates is expressly authorized by a resolution of the board to issue a notice under the code. So a general authorization, a general power, or somebody saying, I write to you under the instructions of so-and-so, an operational creditor is not going to suffice. So practicing lawyers should know that this is going to trip them if they are appearing for operational creditors and rely on a notice not authorized by the board specifically. Similarly, recently in a case that came up before the NCLAT, which is called the Palogix case, which I have referred to in para 31, again the question arose, what happens if the proceeding itself is initiated at the instance of a power of attorney holder? You know, we all know that powers of attorney generally contain the power that institute do proceedings and whatnot and legal proceedings. Now, this came up for consideration and the NCLAT has said no, these type of general powers of attorney with power to institute proceedings, legal proceedings and whatnot are not going to suffice for the purposes of the code. It has to be this type of a proceeding under the code must be specifically authorized by the board of the company if it is a corporate entity that is instituting a proceeding under sections 8 and 9. So again, to bear in mind that please do not institute it based on some usual power of attorney that you would otherwise use in court or legal proceedings. Then the Supreme Court thereafter sets out in detail, which I have put here for your benefit at page 17, what are the required particulars to be filed along with the application and the time within which all these applications are to be heard, considered and disposed of. Now if you will see this, the summary, because the earlier part has been summarized fortunately by Justice Nariman in paragraph 25, which I have set out at page 18. I think if you could read that, it will give you a bird's eye view of the provisions of the code with regard to operational creditors. Whether there is an operational debt as defined which exceeds 1 lakh. So now you have a threshold of 1 lakh minimum. Whether the documentary evidence furnished with the application shows that the aforesaid debt is due and payable and has not yet been paid. Because this has to be certified that no amount of the debt has been paid. That has to be certified by another financial institution or bank that after the notice was issued, no amount has been received. Whether there is existence of a dispute between the parties or the record or the record of the pendency of a suit or arbitration proceedings filed before the receipt of the demand notice of the unpaid operational debt in relation to such dispute. Please mark the use of the word or in subclause 3. Whether there is an existence of a dispute, subclause 3, between the parties or the record of the pendency, not and, because a lot of time before the Supreme Court gave this decision, the word was used, which was used in the code was and it was interpreted as a conjunctive and. It's not conjunctive, it's or. If any one of the aforesaid conditions is lacking, the application would have to be rejected. Apart from the above, the adjudicating authority must follow the mandate, etc., and proceed with the matter. Then, what about the satisfaction with regard to the existence of a dispute? Again, the Supreme Court has dealt with that in the context of an operational creditor. And if you see the highlighted portion of paragraph 29, which I have quoted in para 35 at page 19, the last sentence is enough for our purpose. The moment there is an existence of such a dispute, the operational creditor gets out of the clutches of the code. I thought it was the debtor who got out, but anyway, that's the Supreme Court for you. Now, an interesting question which came up before Justice Nariman was, what happens to the old law that we've all been used to as appearing for companies facing winding up proceedings? This is a bona fide dispute. We have been always hearing that times out of number being said in the company court. So the Supreme Court had to consider, does a dispute or an existence of a dispute include the age-old test of the dispute being a bona fide dispute? And the Supreme Court has categorically said no. And if you will kindly see the paragraph that I have quoted from Kirusa and paragraph 38 overleaf, page 20, it is important to notice that 255 read with the 11th schedule of the code has amended 271 of the Companies Act of 13 so that a company being unable to pay its debt is no longer a ground for winding up a company. The old law contained in Madhusudan, which held the bona fide disputed test, has therefore disappeared with the disappearance of this ground in section 271. And if you see further in the next paragraph, in its present avatar, section 5 subclause 6, which excludes the expression bona fide, which is of significance. Therefore, it is difficult to import the expression bona fide into section 82A in order to judge whether a dispute exists or not. And therefore, the question which would arise immediately in the mind of a lawyer would be, so what is it that the adjudicating authority must do? That is answered in the next quote in the same paragraph. All that the adjudicating authority is to see at this stage is whether there is a plausible contention which requires further investigation and that the dispute is not, now look at the test, is not a patently feeble legal argument or an assertion of fact unsupported by evidence. It is important to separate the grain from the chaff and to reject a spurious defense which is mere bluster. So you have various expressions used which tell you how narrow the scope of adjudication is. However, in doing so, the court does not need to be satisfied that the defense is likely to succeed. The summary suit test not to be applied. The court does not at this stage examine the merits of the dispute except to the extent indicated above. So long as a dispute truly exists, in fact, and is not spurious, hypothetical, or illusory, the adjudicating authority has to reject the application. I am sure courts are going to have a lot of time to interpret the word spurious, hypothetical, illusory, or bluster as we go along, and this act comes in for interpretation time and again. Then, on the existence of dispute, again the Supreme Court elaborates on the next page which I have quoted. Going by the aforesaid test of existence of a dispute, it is clear that without getting into the merits of the dispute, the appellant has raised a plausible contention requiring further investigation, which is not a patently feeble legal argument or an assertion of facts unsubstantiated by evidence. The defense is not spurious, mere bluster, plainly frivolous or vexatious. A dispute does truly exist in fact between the parties, which may or may not ultimately succeed. So in other words, the emphasis as I see it, to put it in a nutshell, is was there a dispute which was pre-existing between the parties? And is that dispute something that the facts support, or is it only created as a legal defense, or what was called previously a classic lawyer's defense after the notice has been received? So that has now gone out of the window. The next quote, which I have put in paragraph 41, is where the Supreme Court distinguishes, or rather not distinguishes, but interprets the word and appearing in 82A to mean or and not and. So it's not a conjunctive and, therefore there need not be a proceeding in a court or an arbitration in order to satisfy the NCLT that there exists a dispute. So that is an interesting interpretation that has been already done within less than a year of the code coming into force. Then we have section 10. Now section 10 is again unique in that sense because it's a departure. It's a departure because previously under the Companies Act, a company liable to be wound up, the word liable not meaning insolvent but liable meaning subject to the provisions of the Companies Act, could apply under 391, 394 with a scheme of revival, and it required you to go through the entire gamut of calling of meetings and this and that and the other and whatnot. Now you have a possibility where a corporate debtor itself, which has committed a default, the key words are a corporate debtor which has committed a default gets a right to come under section 10 and initiate the insolvency resolution process by itself. The advantage, of course, would mean that if it is admitted, it would, from the date of the admission, the corporate entity would enjoy a moratorium under section 14, similar to section 22 of SICA. Now, question is, so what is so different about this versus SICA? The answer is very simple. One, upon the petition being admitted or application being admitted, the insolvency resolution professional, who is the professional defined under the code, takes over. The management vests in the insolvency resolution professional, so the previous management must bow out. The IRP, as he is called, insolvency resolution professional, is then charged with the duty of carrying on the business of the company and the affairs of the company, so the promoters lose their right to interfere in the management, and there is very, very strict timelines to be observed of 180 plus 90 days. So within that period, if the company can be revived, it will be revived, or else it will be wound up. So there is no incentive for a management which has caused sickness, as it was happening under SICA, to apply for file a reference and try to say that I need protection because I am now being revived. So this is the important distinction that has been made. Now the question which arises is, what happens when the corporate debtor wants to go under section 10 and there is a winding up petition which may have been filed and which may be pending before the High Court? As you all know, under the transfer notification which came on 7th of December 2016, if notice of the filing of a winding up petition had been issued to the company or a provisional liquidator appointed, those proceedings would remain in the High Court. All the other winding up petitions were automatically sent to the NCLT. So there are, even today as we speak, several winding up petitions pending in this honorable court, where orders of admission or appointment of provisional liquidator may have been made. The immediate question therefore arose before the NCLT was, what happens when there are two jurisdictions or two authorities or two courts exercising jurisdiction, one being the company court, which has already admitted the petition, the other being the NCLT, where the corporate debtor may go and say, I need protection, I must get that protection, I am entitled to apply under section 10. This issue is currently alive. It is in fact, I happen to be in the matter that is mentioned here in paragraph 47, the Jotun PSL case, which is going to be heard next week, hopefully, where the court is going to decide this question, because a company judge of our court, without a reasoned order, passed an injunction restraining the NCLT from proceeding with the corporate debtor's application under section 10. It was challenged in appeal on the ground that the company court has no jurisdiction under the Companies Act to injunct a proceeding pending before the NCLT which the corporate debtor is entitled to initiate, given the fact that section 64 subclause 2, you may look at it at your leisure, injuncts every court or any court from granting an injunction with regard to proceedings which may be filed or capable of being filed before the NCLT. So this is going to be decided soon. But at the same time, Justice Dhanuka, who we have here, has given us the benefit of a judgment in the Parekh Aluminex case, where he had to consider whether section 238, which is the overriding section as I mentioned earlier, would result in one of the two proceedings having precedence or priority. Justice Dhanuka has held that 238 has no overriding effect. In fact, there is no inconsistency, and proceedings both before the NCLT as well as the winding up court can go on simultaneously. Of course, if a provisional liquidator were to be appointed, you'd have to come to the High Court and take the leave of the court under 446 to continue the proceeding before the NCLT. So to that extent, we have a judicial pronouncement that 238 certainly will not prevent either the winding up court or the NCLT from exercising their respective jurisdictions. Another interesting point of law which has arisen very recently is with regard to the applicability of the law of limitation to applications filed before the NCLT. I have dealt with that at pages 25 onwards, where this question arose in the case of Neelkant. What happened was, in the case of Neelkant, the NCLT actually examined the issue from the point of view as if the Limitation Act did apply. And after examining that the claim was made within time, proceeded with the matter. The matter was carried higher, and the argument before the NCLAT was that whether the Limitation Act will apply or not is a moot question. The NCLAT in Neelkant has come to the conclusion that this is not a proceeding for recovery of money. It is not a proceeding for recovery, it is in fact a proceeding to bring about a resolution process, and therefore the Limitation Act will not apply. Matter did not rest there, went to the Supreme Court. The Supreme Court did not interfere with the NCLAT but has kept the question of law open. Now, when you keep a question of law open, it means the question of law which has to be decided as yet afresh will be whether NCLT can be regarded as a court, because what the NCLAT did in a subsequent judgment, the appellate tribunal did in Black Pearl's case, was to say that we have already held in Neelkant that this is only a process of recovery. Then they went on to say, no, but this code came into force in December 16. So we will apply Article 137, the residuary clause, and it will be 3 years from December 16 when you can bring your application for a resolution process before the NCLT. Now that begs the question, because 137 is part of the Limitation Act. Limitation Act applies to courts, and whether NCLT is a court or not therefore becomes a moot question. This has not yet been decided, because why this is important is because in the case of Kalyani, which was argued very recently by me before Justice Gupte, Justice Gupte came to the conclusion that the Company Law Board, which was the tribunal prior to the NCLT, even though it has all the trappings of a court, etc., and acts in a judicial, has to require to act in a judicial manner, and appeal lies only on a question of law to the High Court from any decision of the CLB, etc., nevertheless came to the conclusion that whereas all courts are tribunals, all tribunals are not courts, and the CLB is therefore not a court. Now, therefore, at some stage, someone or the other will have to decide whether the NCLT is a court and whether even 137 has any application or not. And of course, interestingly, Section 433 of the 2013 Companies Act says, for the purposes of the Companies Act, that is, when it is exercising powers under the Companies Act, the NCLT is to be regarded as a court. But here it will be exercising powers as a court under or a tribunal under the code and not under the Act, Companies Act. So that makes it even more interesting for lawyers to argue. Then another question which has recently arisen and which is interesting, arising out of the provisions of the code, is what is the status of flat purchasers? Because these flat purchasers sometimes are claiming a refund, sometimes are claiming interest. Are they operational creditors? Are they financial creditors? What is their status? Can they invoke the code? Because you see a lot of litigation initiated by the flat purchasers who often have to resort to proceedings in courts which may take a long time. So this question arose in Nikhil Mehta's case, and the NCLT rejected it, but the NCLAT said, no, if there is a situation which could be compared in that sense with an assured return situation or like a loan, then the flat purchasers could qualify as financial creditors because there is time value of money involved in the repayment of the loan. So that becomes an interesting question because it will assist flat purchasers to have a quicker remedy available to them versus going to the civil court. Then there has also been an amendment made to the regulations which I have referred to at page 28, where regulation 9 capital A has been added. Now this arose because one of the duties which is required to be performed by an IRP or the insolvency resolution professional is to invite claims after he is appointed. And the question is therefore, from whom can he invite claims? Because the two categories of creditors who can apply for a resolution process are only operational or financial. So is it restricted? In other words, do claims have to come only from these two categories of creditors or can it be from others? So regulation 9A has been amended by the first amendment made on 16th of August 2017, as late as that, to say that claims can be entertained by the IRP from creditors other than operational and financial creditors. This may again give a window to flat purchasers or people similarly placed to go and make their claim before the IRP. Then the process of corporate insolvency resolution, as I already indicated earlier, is extremely time bound. And the Supreme Court, as I said earlier in the innovative case, has indicated that this is an important element of the code. But I may just read to you, after the Supreme Court refers to that 180 days, etc., in the first few lines of the paragraph that I have quoted from innovative. Kindly see, after saying 180 and then not exceeding 90 days, what happens thereafter. The matter goes to the committee of creditors. See the fifth line of the code. And if the committee of creditors by voting 75% so decides to take the company out of, in that sense, give it a fresh start, then of course the company would come out of the resolution process and be revived and would be put back on its feet, as the Supreme Court has said in paragraph 31, and it would stave off the liquidation process. So the moratorium kicks in after the petition is admitted under section 14, and the interim resolution professional will be vested with all the powers of the board, and he would be then required to invite claims from various creditors. Then there is also called what is called the committee of creditors, which can only comprise of financial creditors. Now this is important because when you talk of 75% vote, which are the creditors who are entitled to vote for revival? Only the financial creditors. And if there are no financial creditors, then what happens? Then there is a mechanism provided that the Insolvency and Bankruptcy Board of India, which is constituted under section 188 of the code, will decide which creditors will have the right to vote whether to take the company into liquidation or whether to revive it. So that is a new feature again of the code. Then the innovative case tells us a few things in paragraph 31, which is that the vote must be of not less than 75% of the financial creditors voting. IRP can raise finances, create security, but only with the prior approval of the committee of creditors. Now this committee of creditors, as I mentioned earlier, comprises of financial creditors. So in that sense, IRP does not have a free hand. He can't do what he likes. He has to refer the matter to the committee of creditors. Then any person, the interesting thing is, who can give a revival plan? The language used is any person. So it need not be the management, it need not be the promoters, it need not be a financial creditor, it could be anybody, operational creditor or just even a complete stranger can come out with a revival plan. and resolution plan as it is called, and he would then be called a resolution applicant. So that resolution plan prepared by A or B or C will be submitted to the IRP. The IRP will vet it, keep it, place it before the committee of creditors, and if it is accepted, the company comes out. Otherwise, as the Supreme Court says in the last sentence, and this is the expression used by Justice Nariman, para 63, page 30, or else the chopper comes down and the liquidation process begins. So this is how the code envisages the revival of corporate debtors. Then I have also dealt with the restraints or constraints in that sense on the powers of the resolution professional which are laid down under the Act. And he also, not only are there constraints or restraints on him, as I said, that he can't do what he likes, he has to take the approval of the committee. There are also certain duties which he is required to perform, such as collection and collating of claims received under section 13 and 15 of the code, constituting the committee of creditors, take control of the assets of the corporate debtor, and take charge of the management and affairs of the company. Then he is also required to invite proposals from anybody who would like to bring about a revival plan. Now, when I looked at the code, I found that the position of the IRP seems to be similar to an administrator appointed under the Cooperative Societies Act. Under the Cooperative Societies Act, as you all know, an administrator can be appointed, but his role would be limited to ensuring within the statutory timeline to hold elections and hand over management back to a committee which is lawfully or validly elected. Here the difference is that the IRP does all this which is required to do, calls for proposals, puts it before the committee, and basically within 180 plus 90 days, he has to ensure that either the company comes out of liquidation or is revived or goes into liquidation. So that's the role of the IRP as I see it in a nutshell. Then recently there has been some move, and we read that in the papers, as to whether promoters who have caused the sickness, so to say, I'm using a loose word, caused the company to default, I may use the expression used in the code, to commit a default, whether those promoters have a right to bid or come out with a resolution plan. That's being currently debated, and we may have very soon a view on it. But as we stand, as we speak today, promoters can bid, but there is a restriction only after they have established their credit worthiness. The debate is whether they should be allowed even then. So we will see what happens and what comes out of that. And then what are the factors which have to be taken into account with regard to the scheme that is propounded have also been laid down, because all that has to be placed in the form of an information memorandum, which again is the duty of the IRP to prepare and provide to people so that they can decide whether or not to come forward and become a resolution applicant or not. Then again, the importance of timelines is re-emphasized in the innovative case. I would like you to look at that, because you can see how often Justice Nariman has emphasized the importance of time. Please see the quoted paragraph at page 34. It says the entire process is to be completed within a period of 180 days from the date of admission of the application under section 12, and can only be extended beyond 180 days for a further period of not exceeding 90 days if the committee of creditors by a vote of 75% of voting shares so decides. So it is not 180, okay, I have not been able to do my job, I must have 90 days. No, it must go back to the committee of creditors. It can be seen that time is of the essence in seeing whether the corporate body can be put back on its feet so as to stave off liquidation. And even in the Kirusa case, I have quoted that paragraph too, where again Justice Nariman has emphasized the adherence of timelines. And he in fact tells the NCLT as well as the NCLAT in the last 4 lines which I have quoted, both the tribunal and the appellate tribunal would do well to keep in mind the principal objective sought to be achieved by the code and will strictly adhere to the time frame within which they are to decide matters under the code. Then another interesting question which arose recently before the court, NCLT, and went right up to the Supreme Court was, what happens when an application under the code has been admitted? Can it be settled or not be settled? So I happened to be appearing for the corporate debtor, and the NCLT had admitted the petition. By the time we could go and appeal, the LAT was not sitting. The appellate tribunal for that week was not available. So we filed a writ. By the time the writ came up, the parties decided to settle their disputes. Consent terms were drawn up. They were put before the High Court for the passing of an order. The High Court took a view that it is better that this is done before the NCLAT, because now the LAT is available, so you should go back to the LAT. So the parties went to the LAT and tendered the same set of terms, saying that this is a conditional set of terms which says only if payment is made would the order of admission be set aside. The LAT said, sorry, we do not have jurisdiction. It is not like the Companies Act that you can advertise, call for other claimants to step in. No, we do not have jurisdiction, period. We cannot settle this dispute for you. So being agreed by that, because both parties had by then acted on the settlement, monies had been exchanged, terms had been signed, resolutions had been passed. Now what do? So they went to the Supreme Court, and the Supreme Court affirms the position in law that once it is admitted, it can't be settled. But in order to do complete justice, they exercised the powers under 142 of the Constitution, Article 142, and took the settlement on record and allowed the parties to dispose of the application. So this is how the matter stands insofar as corporate insolvency is concerned. The liquidation process itself, if it has to be initiated, would be initiated when the resolution process fails and an application has to be made before the NCLT stating that either there is no resolution plan within the 180 plus 90 days, or the NCLT rejects the plan, or if the IRP tells the NCLT that the committee of creditors has rejected the plan, or if there is a breach of the conditions set out in the plan which has been approved. So these are 4 situations in which the order of liquidation can be passed by the NCLT. And then of course you have the usual powers which are there similar to the Companies Act with regard to liquidation of the company if the revival process has not gone through. The only thing of interest over here is that the priorities which were laid down under the Companies Act have been slightly altered, and I don't want to trouble you with what that alteration is, except at page 42 you may find that the priorities have been set out over there, and you will find that workmen's dues have been again placed on par with debts due to the secured creditors, and then the other amounts which are due to the government, etc., what not, come under the under priorities which are mentioned there. So there is also a fast track process of insolvency resolution which is to be found in chapter 4 and which is basically for startups and other than partnership firms. So that's another change which has been made, which is basically requires the entire thing to be completed within 90 days. And then you have, of course, the voluntary liquidation, which is again in chapter 5. So this is how the code stands as at present. There's bound to be a lot of development in the law as we go along. But just to give you a brief overview, this is how it stands. The second part of the code deals with insolvency and bankruptcy for individuals and partnership firms. Now, as you all know, prior to the enactment of the code, there were two laws dealing with individual insolvencies or insolvency of individuals. The Presidency Insolvency Act, which was applicable to the three presidencies of Kolkata, Mumbai and Chennai, and the Provincial Insolvency Act, which was applicable to the rest of the country. Now everything has been brought under one umbrella by the code itself, and these two acts have been repealed. As a matter of information, I may tell you that the section bringing the code into effect has not yet been notified, so we are looking at the provisions in an academic way, awaiting the notification of the chapter dealing with individual insolvency and bankruptcy and of firms. Now, what are the features? I'll just quickly run you through them because time is short. The procedure is a slightly different procedure from corporate insolvency because unlike in the case of a corporate debtor where the ownership can change, there cannot be a change of ownership insofar as individuals are concerned. So there can only be a question of revival if some kind of a fresh start being given. So and that is why the committee that was formed for the purpose of bringing about the necessary changes and the provisions of the code has categorically said, and I have set it out at page 47, that firms can be liquidated but individuals cannot. So the second important feature is whereas you can liquidate a company, liquidate a firm, you cannot liquidate an individual. But what the Act attempts to do is to simplify and provide what is called a fresh start, which is the most important feature of this part of the code. That is to give a fresh start to people. And why? Why is it required? Because there are some statistics given by the committee at page 48, which you might find in the middle of the quoted paragraph. Small and medium enterprises contribute more than 45% of industrial input of India, 40% of the country's total exports, and create 1.3 million jobs every year. Indian small and medium enterprises employ close to 40% of India's workforce. India has a weak record on recovery of loans to individuals and to small and medium enterprises. Either recovery is difficult and leads to creditors incurring losses, or recovery takes place through the use of coercive practices, which leads to debtors incurring losses. Given the importance of such borrowers in the economy, the committee believes that a fresh approach to individual bankruptcy is an important goal. So this was the reason behind the code being enacted for individuals. The term insolvency is not defined. I would have thought that it would be very much there, but it is not defined in the code. It is defined in the Sale of Goods Act, and it refers to a person, section 2(8) of the Sale of Goods Act, a person who had ceased to pay his debts in the ordinary course of business or cannot pay his debts as they become due, whether he has committed an act of insolvency or not. So in other words, insolvency refers to a state of mind or an act on the part of the individual, whereas bankruptcy is a declaration made by a court. So the difference between insolvency and bankruptcy is, insolvency is something which a person does or is unable to do. Bankruptcy is an adjudication made at the instance of a court or a tribunal, as in this particular case. So that is the difference between the two words. You may note those. I have set them out for your benefit at pages 49 and 50. Then the most important part of this code is the fact that it is meant to give a fresh start. And that is what part 3 of the code is all about. I have referred to that in paragraph 117. Then there are all these definitions which are again not so relevant at this stage. But if you turn to page 52, you will find under the heading of chapter 4, fresh start process. This process lies before the DRT. You may note that. So it is individuals have to go to the DRT and not to the NCLT. And the report of the Committee on FSO, or Fresh Start process, is to be found at page 121. And the important aspect here is only a debtor can go, not a creditor. Only a debtor can file for an FSO or a fresh start procedure. Then then there are certain categories of debts which qualify. There are certain categories of debts which are excluded, and therefore you have to be careful when you apply under the FSO procedure whether it is a debt or a default of which falls within the included or the excluded category. Then again, unlike in the corporate debtor situation, there are two moratoriums which operate in the case of FSO, that is a fresh start offer. Because here, in the case of corporate debtors, it is only after the petition is admitted. In the case of individuals, it starts from the time the application is made, the first moratorium. After it is admitted, second moratorium. So therefore, that is another departure from the corporate debtor situation. Then there is an eligibility criteria laid down by section 80, which I have set out at pages 54, 55. And therefore, as I said, one has to be careful whether you are eligible or not eligible. And then you come to page 57, where there is again an insolvency resolution process, which is similar to that of the corporate debtor process for resolution. And again, even in this case, at page 60, you will find that you require a 3/4 majority in order to give a fresh start to a person who is claiming the benefit of this process. So this basically summarizes what the second part of this talk is all about, at least as far as I am concerned. I would like to thank you once again for the patience you have shown, and thank you to the Bar Association for inviting me.
Thank you, sir. You really made such a complex subject so easy to understand for our members. Thank you so much, sir. And just one second. May I, before he leaves, the gift in, may I request Ms. Yasmin Tavaria to present a small token of our gratitude to Mr. Dwarkadas. Honorable Justice Dhanuka, who will speak to us about the jurisdiction of the tribunal and the debt recovery tribunal in connection with the various insolvency provisions, bankruptcy and insolvency provisions.
The committee of the Bar Association to invite me to share something what little bit I know in this subject and to learn more from the two eminent speakers, one who has just delivered his lecture, Mr. Dwarkadas, and Mr. Doctor. I am going to sit here till he concludes his lecture to complete my training. I was slightly unwell, but since morning I am surrounded by 3 doctors, 2 on the left hand side and 1 on the right hand side. So with the fear that they will give me some strong treatment, I feel better. We are all aware that prior to December 2016, we were all familiar with the Companies Act 1956 and 2013. It was very simple to file a company petition because everybody was aware that suit will take 20 years. So if any crystallized due is there, more than, initially it was 500, thereafter it became 1 lakh. So you give a notice, statutory notice of 21 days. Most of the time there will be no reply to statutory notice. So you file a petition, petition will be heard expeditiously. It will be first, it used to come for acceptance first. Now that procedure was given a go by, and the company registrar does that work of acceptance of the company petition. And then within a year or two, the latest position was that matter used to be heard for admission. And at that stage, most of the companies used to settle the matter. It was more and more used as a threatening proceedings to say that matter is settled amicably instead of waiting for 20 years on payment of token amount of court fees. Company petitions used to be entertained. That was one of the important aspect why those proceedings were more and more filed in this court. Maybe that the legislature has thereafter thought fit that instead of filing these proceedings, some proceedings before DRT, some before SICA, some before Companies Act, Companies Court, all should be brought under one roof. And that was the purpose that Insolvency and Bankruptcy Court was enacted in 2016. As you all know that this NCLT, National Company Law Tribunal, was brought on record in place of court in the provisions of Companies Act 1956 in the year 2001 itself. But constitutional validity of that was challenged by Madras Bar Association in the Madras High Court. And unfortunately, the Madras High Court took a view that constitution of National Company Law Tribunal and NCLT was unconstitutional. That order was challenged by the Madras Bar Association as well as by Union of India before Supreme Court, and Supreme Court fortunately reversed that decision. Thereafter a committee was appointed, that committee made some more suggestions, and then this Act of 2013, Companies Act 2013 was enacted, followed by 2016 Insolvency and Bankruptcy Code, bringing most of the provisions of these three acts under one roof. Mr. Dwarkades has already apprised us of all these provisions. Now, what is the basic difference between the proceedings of winding up which we used to see under the provisions of Companies Act 1956 and 2013 Act? That if your claim is more than 1 lakh rupees, you give a statutory notice, there is no reply, there was a deemed provision that the company is unable to pay its debts, you file your petition, petition will come on board for admission, and the court will take a decision whether to admit a petition or not. Once petition was admitted, there was a provision for advertisement of the order of admission of the petition. Court could appoint even provisional liquidator at the admission stage, followed by final hearing of the matter and final appointment of the official liquidator. Now the situation is not that under the provisions of Insolvency and Bankruptcy Code and read with the provisions of Companies Act 2013. Now there is no automatic provision for seeking a dissolution, seeking a winding up of a company. The concept is totally changed under the 2013 Act read with Bankruptcy and Insolvency Code. Now you have to seek for resolution process, for revival of the company at the first instance. Who can file these proceedings? One is operational creditor, another is financial creditor, or the company debtor, its corporate debtor itself also can file for resolution process. Financial debtor can file a proceeding even without notice. Operational creditor has to issue a notice. If within 10 days there is no sufficient reply from the corporate debtor, then an application for resolution process can be filed before the NCLT, because NCLT is declared as an adjudicating authority by the government by issuing a notification under one of the provisions of Insolvency and Bankruptcy Code. Now, the procedure is very expeditious. That is one of the advantages of formation of NCLT, that within 14 days from the date of receipt of an application for resolution process, the NCLT is to take a decision whether to admit that application or not. If there are any defaults, then an opportunity has to be given for curing that defects. If defects are cured, then NCLT will decide whether to pass an order of admission. One of the questions arose before Calcutta High Court that at this stage, when NCLT makes an order for admission of the application for resolution process, whether hearing is contemplated or not under that provision, because section is silent about the hearing to be rendered by the NCLT before passing any order of admission or dismissal of the petition. Calcutta High Court took a view that the consequence of any order passed by the NCLT, whether to admit or to reject, is very harsh, and therefore, though the Act is silent about rendering any hearing to an applicant for resolution process, the principles of natural justice has to be followed. Now, I don't know to what extent it will be feasible, because NCLT is to pass an order of admission or rejection within 14 days from the date of receipt of an application from a financial creditor or operational creditor. 14 days, we are all unfortunately used to a system where 4 weeks for adjournment, 4 weeks for filing reply, 6 weeks for rejoinder, and then counsel is not available and that is not available. The proceedings go beyond the control of the court. At least as a judge of the High Court, I am happy that these proceedings have gone to NCLT. So we can do some other work. The High Court is already overloaded with lot of work. So once an application is admitted by NCLT, after considering the material on record, NCLT is to pass an order for admission and for declaring a moratorium. Once an order of moratorium is passed, then that order has to be published, because the consequence of passing an order of moratorium is very serious insofar as the creditors are concerned, because all their recoveries are stayed, all proceedings are stayed wherever they are filed. Do you want to file any further proceedings against this company? Corporate debtor, they are also stayed till the entire process of resolution process is completed within a period of 180 days prescribed under the provisions of Insolvency and Bankruptcy Code. The next step has to be followed by NCLT once an order of admission is passed, is that interim resolution professional is appointed by the NCLT. Once that is done, then all the powers vested with the management of such corporate debtor, they are suspended. Once powers are suspended, they can't do any business, they can't take any decision to run the company. All such decisions are taken by interim resolution professionals. Then claims are invited from all the creditors by publishing the order passed by the national NCLT of declaration of moratorium. And after collation of all these claims by the interim resolution professionals, a committee of creditors is appointed. Committee of creditors thereafter jointly with ARP has to take a decision whether a proposal for resolution has to be submitted or not. That decision has to be taken by 75% of the financial creditors insofar as their voting powers are concerned. And once that is finalized, then that proposal is placed before the NCLT again for final orders. Thereafter, the NCLT will come to a particular conclusion whether to go ahead or not. After possessing all this data, list of creditors, the assets of the principal judgment debtor has to be collated. A final call is given and then a decision is taken whether to pass a final order of moratorium or not. As a result of this, as I told you, all proceedings, wherever they are stayed. A question arose before my court when I was taking company matters, that in one matter, the NCLT had passed an order of moratorium under section 14. And the other petitions against the same company were pending before my court. Question arose that this order of moratorium passed by the NCLT under section 14 will be binding on High Court exercising company jurisdiction or not. The question was very interesting whether High Court is superior than NCLT or not. But I rejected that argument and I held that in view of section 14, the mandate is very clear that once moratorium is declared under section 14, then wherever the proceedings are, whether High Court or before any authority, the proceedings which are filed, they are stayed. The proceedings which are going to be filed against the company in default, even that also can't be filed. Recently, few days back, now I have included that in my note, an issue arose before the Supreme Court whether arbitration proceedings are also stayed or not. Supreme Court took a view that once moratorium is declared under section 14, then even arbitration proceedings are stayed. You cannot go ahead with arbitration proceedings because language of section 14 is very wide. Any proceedings would include arbitration proceedings. Supreme Court had stayed the arbitration proceedings initiated pursuant to an order passed by the High Court. So once a decision is taken by NCLT that further steps should be taken to pass a final order of resolution, at that stage the committee of creditors may take a view, financial creditors, they may take a view that let us go ahead with appointment of the resolutional professionals. They may be substituted, the IRP may be substituted by resolutional professionals or some other person may be appointed. Now, who are these ARPs and resolutional professionals? There is a separate provision provided under the Insolvency and Bankruptcy Code. These professionals are maybe chartered accountants, maybe company secretaries. They are experts in the field and they are not just simply sitter appointed. There is not walk-in interview. Anybody can enter. They have to appear for examinations. There is a separate board. That board has to appoint those experts and they are thereafter representing this corporate debtors in all the proceedings. Even in High Court, I have seen these ARPs are representing the companies in some of the proceedings. Some chartered accountant appeared before me in one of the matter. It was an I think liquidator's report, and he represented the company. He made some proposals on behalf of the company. So once this process is over, and after 180 days, within 180 days, a final decision has to be taken by the adjudicating authority, which is NCLT, whether to go ahead with the resolution process or not. If it is rejected, then it will be followed by an order of liquidation. So once company is in liquidation, then your remedy will apply. You can challenge that order before the appellate tribunal situated at Delhi. As far as Bombay is concerned, all of you are aware that we have the Bombay bench somewhere in the fountain area, and there are 3 courts, I am told, two courts in Bombay. We have jurisdiction of Chhattisgarh state, we have jurisdiction of Maharashtra, we have jurisdiction of Goa. Other benches also, I was going through the study material given to me by Dr. Sate, that most of the tribunals except 1 or 2 are given jurisdiction of number of states. I don't know, it was a good object that we take away the jurisdiction of High Court, we take away the jurisdiction of Company Law Board, BIFR, AIFR, and give it to a specialized body. Intention is very good, undoubtedly. But unfortunately, there is no sufficient infrastructure provided by the government. You want to expedite everything. On paper it is very good. 180 days, even company petitions in our court used to take sometimes more than 3 years. So 180 days is just nothing. 180 days out of that, within 14 days, if NCLT is to decide whether to admit a petition, whether an order of moratorium has to be passed or not, 14 days nothing happens. And the jurisdiction of NCLT, what I have seen is, it is not only to hear the applications for moratorium and resolution process, but large number of jurisdictions which are transferred from BIFR, from DRT and whatnot. We are also responsible to some extent. Fortunately, Justice Gupta has taken a view that those proceedings where notice was not served under Rule 26 before 15 December 2016, those matters only go to NCLT, rest of the matters had remained in High Court. One interesting issue arose before me, where I had followed Justice Gupta's order, Justice Gupta's judgment. Justice Gupta had taken a view that if notice under Rule 26 is not served, then those matters will go to NCLT, rest of the matters will remain here. I have followed that judgment in another matter, where the argument was that 10 petitions against the same company, corporate debtor, they are lying in my court for last more than 3 years. And one petition is filed against the same corporate debtor during the pendency of this petition, which is filed before NCLT. The argument of the learned counsel for the corporate debtor was that you hold on for some time, my application is pending. Application of another creditor against me is pending before NCLT. There are good chances of my revival before the NCLT. Once you hear this matter, I know what is going to happen. Therefore, please wait for some time. Let these 10 proceedings be adjourned for some time. This suggestion was vehemently opposed by obviously by the petitioners, that we are waiting for our matter to be heard for last more than 3 years, and merely because one petition has gone directly to NCLT, why should we wait? So I had occasion to follow the judgment of Justice Gupta in Parekh Aluminum's case, and the view taken was that under section 238 of the 2013 Act of this, Insolvency and Bankruptcy Code, there is no inconsistency between the provisions of Companies Act 1956, Companies Act 2013 and the Insolvency Code. Because of the provisions under 434, which permitted that the proceedings will be transferred at what stage. Under that provision, there are transfer rules were framed by the central government, transfer of proceedings, where it was decided that if the notice is not served under Rule 26 by a particular date, then only by 15 December 2016, only those matters will go to NCLT. The another argument advanced before me was that if provisions of Insolvency and Bankruptcy Code are more better than Companies Act, and these proceedings are very harsh under the provisions of Companies Act 1956 and 2013, there is possibility that there may be conflicting orders. One set of orders may be passed by the NCLT, another set of orders passed by the Company Code, jurisdiction exercised by this court. I took a view that unfortunately both these proceedings, because of the rules framed by the central government where cut-off date is decided, two sets of proceedings against the same company can be decided by two sets of authorities, one by NCLT and another by High Court. I don't know what happened in appeal. I am not supposed to know what has happened in appeal. But that judgment, I remember that I had delivered that judgment. Another issue arose before me about jurisdiction, interesting issue I must tell you. Under section 560 of the Companies Act, 1956, the Income Tax Department had challenged an order passed by the registrar, striking of the name of the company from record. And that matter was pending for last 2-3 years in this court. It was argued before 5 or 6 judges. Unfortunately, the arguments were not concluded and judgment could not be delivered. In the meanwhile, these provisions came in the year 2016, December 2016, and the transfer of proceeding rules were also enacted simultaneously. Insofar as other proceedings other than winding up proceedings are concerned, the transfer rules provided that those proceedings will be transferred to NCLT unless judgment is reserved. The purpose of providing that criteria was that if the arguments are concluded and judgment is reserved, at least those proceedings should not be transferred to NCLT, otherwise again you have to argue the matter before the NCLT, again time consuming, litigants are put to cost twice. The argument advanced before me by the learned senior counsel appearing for the department was that that provision is a discretionary provision. Because see our fate, 5-6 times we have argued before your brother judges, matter remained parted for whatever reasons. So you please exercise your jurisdiction and interpret that provision in such a way that where arguments are substantially heard but not concluded also should remain in this court. We will be more comfortable if these proceedings are heard before your court. I said, I have no choice. There is no discretion given to the court that if arguments remain unconcluded, then it can be heard here and remaining matters can be transferred. I had to dismiss that petition and that matter was transferred to NCLT. So these are some of the provisions which are very drastic, which I feel, but the qualification, I was going through the commentary on this subject yesterday night. Qualification for appointment of the members of the NCLT, one judicial member and one technical member. Judicial member includes a judge of High Court, maybe judge may be district court judge, and any advocate of 10 years standing. But as far as the qualification of technical members is concerned, what was surprising, I can't make any comment more than this, is that member of labor court and industrial court also is eligible to be part of NCLT. Now, purpose is good that this jurisdiction from High Court is taken away, where all top counsel of this court and other courts used to appear before the company court. And the same thing continues before the NCLT, where our all top lawyers of this court, senior advocates, junior advocates from all over India are now appearing before NCLT. This is not a subject which can be decided on common sense basis. In one of the seminar, it was my suggestion, I don't know whether anybody liked it or not, but my suggestion was that this is a specialized subject. Some more qualified person should be appointed for the purpose of deciding these matters before NCLT and NCLT. If necessary, these judges also should be given training from time to time. Even High Court judges are sent to Bhopal. We have a Judicial Academy where we are sent to attend some lectures, and it is not necessary that the persons who are called to deliver lectures for the High Court judges are Supreme Court judges. No. The experts in that subject, top lawyers, chartered accountants, company secretaries on different subjects are invited to deliver lectures even for High Court judges. Therefore, as and when that opportunity arises, I would request the committee members of the Bombay Bar Association that if any such occasion arises, our Judicial Academy invites if some of the members for delivering lectures for the members of NCLT, please accept that opportunity, please oblige the Judicial Academy to deliver lectures for our NCLT members. Now, one of the issues touched by Mr. Dwarkadas was about limitation, because whether proceedings before NCLT is proceeding before court or not, if it is not before court, whether Article 137 of the Limitation Act applies or not. these are all legal issues. And I have heard that lawyers are called as eighth wonder of the world. So technical and legal issues are raised, they are entitled to raise. If it is raised, it has to be decided by somebody at some stage. But one paragraph I would like to read from the recent judgment of Justice Nariman. That judgment Mr. Dwarkadas has already dealt with. But I would like to read that paragraph because the issue of limitation is touched by him. It is in case of Messrs. Innovative Industries Limited versus ICICI Bank and another, 2017 SCC Online SC 1025. The issue before the Supreme Court was, in what instances NCLT, which is an adjudicating authority, should admit an application for resolution process. While dealing with that issue, the observation made by the Supreme Court in one of the paragraph was that a debt may not be due if it is not payable in law or in fact. Once the insolvency resolution professional is appointed to manage the company, the erstwhile director cannot maintain appeal on behalf of the corporate debtor. As you all know, that our court has consistently taken a view that winding up proceedings filed under the provisions of 1956 Act could be entertained provided your debt was a legally and subsisting debt on the date of filing an application for winding up. Now, when do you go for resolution process? Because that concept of inability to pay debts is now given a go by and is substituted by default. So if a default is committed, then you go for insolvency resolution process. The purpose is that if it is possible to revive this company, you revive it so that everybody will get their money. If it is not possible, then put this company into liquidation so that assets can be distributed amongst all the creditors. So this particular paragraph of Supreme Court gives some hint that even for invoking a provision under section 7, 8, 9 under the provisions of Insolvency and Bankruptcy Code, the claim must be a debt due. And if it is a debt due, then only this proceeding should be entertained. So far there is no judgment of High Court or Supreme Court on the issue whether provisions of Limitation Act is attracted or not. One matter was there before the NCLT, where NCLT had taken a view that provisions of Limitation Act are attracted to the applications filed under section 7 to 9. But in Supreme Court, the issue of limitation is kept open. Then one or two more judgments I will just deal with quickly. Karnataka High Court, in case of Falcon Tires Limited versus Edelweiss, it is page 21 of my note, paragraph 4 of my note, page 18, has taken a view that any order passed by the NCLT without rendering an opportunity of hearing was in violation of principles of natural justice, and therefore that order was set aside. The interference of writ court, so far I was just inquiring with Dr. Sathe whether our court is interfering with any of the orders passed by NCLT in any under writ jurisdiction. I was told that so far it is not, but some of the orders which may not be appealable, or some of the orders are such that you can't wait for adjudication of those proceedings by NCLT, may come to High Court, because this order what I am referring to is passed by the Karnataka High Court, where principles of natural justice was not followed by the NCLT, and writ court had interfered with that order passed by NCLT. In another matter of Sri Metallics versus Union of India, the issue before the Calcutta High Court was whether the provisions of CPC are applicable to NCLT or not. The Calcutta High Court took a view that as such provisions of CPC may not be applicable to NCLT, but principles of Code of Civil Procedure are definitely applicable to NCLT. About Neelkanth's judgment, Mr. Dwarkadas has already discussed with, I need not take time on that. In Surendra Trading's case, the Supreme Court recently considered an issue that if defects are not removed within 7 days, then what is the consequence of that? So Supreme Court said that nobody is interested in delaying the matter. If for genuine reasons delays, these defects are not cured, and if sufficient reasons are given, then NCLT should consider and shall give an opportunity to remove defects. This latest judgment of Supreme Court in case of Alchemist Asset Reconstruction Company, which I have already dealt with in my speech, that what happens to the arbitration proceedings? Whether arbitration proceedings are also affected because of an order of moratorium declared by NCLT under section 14. Supreme Court said that yes, even arbitration proceedings are also affected by order of moratorium and it cannot be proceeded with. The another topic given to me is about the jurisdiction and in respect of insolvency of individuals and partnership firms. Mr. Dwarkadas has already told you that though a separate chapter is provided under Insolvency and Bankruptcy Code insofar as insolvency of individuals and partnerships are concerned, but till date no notification is issued by the central government for hearing these matters by DRT. One thing, on my personal level, I am little bit unhappy with the manner in which these notifications are issued by the government in piecemeal. Some matters are tried by NCLT, some are tried by High Court. We are waiting for notifications till notifications are issued. Matters will remain in High Court. Now we are continuing to hear the insolvency proceedings against individuals and partnership firms. Though a provision is made by providing a separate chapter under the provisions of Bankruptcy Code in respect of individuals and partnership firm, but because notification is not issued, now one way or the other notification should be issued if your intention is that all these proceedings should be transferred to tribunal so that everybody should get speedier justice. Purpose is very good, but then why are you waiting? Issue notification. Several provisions of Companies Act 2013, no notifications are issued for some reasons. They are issued in piecemeal. I don't feel any purpose of issuing such notifications in piecemeal. Everybody can, otherwise it becomes very difficult. Sometimes even to find out whether notification is issued or not. Half of the proceedings have gone there, half have remained here. Even these company petitions where notices are issued prior to 15 December, after 15 December, personally speaking, I am not very happy with this situation. If you have decided that this must go to NCLT, then it should go to NCLT. Why this notice and this and that? Because the argument advanced before me was correct in that sense that there may be two sets of proceedings. One provisions are more better for the betterment of the corporate debtor, another provision is harsh. But ultimately we are all bound by the law. We cannot exceed our limit. So with this I thank all of you for giving this patience hearing and to the Bar Association for conducting this lecture series. I always feel very happy that this type of lecture series are organized by Bar Association. Unfortunately, when I was practicing, it was not in session. So otherwise I could have waited for some more time to go to judiciary and earn some more money. Thank you very much.
Thank you so much, sir. I cannot help but mention that after a long and exhausting week in court, Justice Dhanuka wasn't feeling too well, but despite that, he has brought himself here today and taken the time out and spent the afternoon with us. We are really grateful to him. And I was full of admiration about the manner in which my Lord Justice Dhanuka summarized the entire act for us in a very, very short time. Thank you so much, sir. So may I request Dr. to please address our members.
Good afternoon, everyone. First, I must thank the Bar Association for doing me the honor of allowing me to speak with as esteemed a panel as this one. I feel quite humbled by the experience. And in response to what Justice Dhanuka said, one of the things that struck me is one of those old sayings, water, water everywhere and not a drop to drink. And doctors, doctors everywhere, but none that can cure him. So, I have been given the subject which at some level today has become academic. In the sense that it's a necessary subject for all of us here to discuss to complete the subject matter in the loop of today's workshop or seminar. However, from a practitioner's point of view, we used to all sort of, our bread and butter was made from company matters, that is company petitions filed by creditors. That was when we practiced company law before the High Court and appeared in company petitions. I think through my entire career, I can only think of a couple of occasions when the company petition was not a creditor's petition. Now that has been done away with, and that has been substituted by effectively the going to the tribunal, the NCLT, as either an operational creditor or a financial creditor. So that part of winding up, which is from a practitioner's point of view a very important part, has completely been obliterated, at least from the Companies Act in that sense. And what remains is a very narrow jurisdiction. And as I said, it's important to know what it is, but at some level perhaps from a practitioner's point of view, it may be academic. Now, I was just grappling with how to deal with this subject, and I thought the best way to position position it or to make it of some relevance for everyone here was to juxtapose it against what the existing law was in the 1956 Act, because all of us were familiar with that, and to see where we have gone from there. So that's the context in which I'm going to address you on this subject. Now, as you all know, winding up was governed under the provisions of Part 7 of the old 56 Act, that is sections 425 to 466. Sections 433 and 434 were one of the most oft-repeated sections in this court, and something everybody here is familiar with. All the provisions of those sections and inside out, and what were the grounds on which you could file a petition, what are the grounds on which a court could entertain a petition, what happens once a petition was filed, what happens once a petition was finally decided, what happens once a provisional liquidator was appointed, what happens once a liquidator was appointed. I think most people here were already familiar with that old law, so I'm going to use that as the basis to move forward. Now, the Companies Act 2013 came into force on 29th August 2013. However, the provisions with regard to winding up did not come into force. It came into force only on 15th December 2016. Now, this date is of a little importance because the Insolvency Code came into force on 28th May 2016. So, what happened is this, that really after the Companies Act 2013 was enacted, all the provisions with regard to winding up were never put into force. The code was first enacted, the sections pertaining to winding up were amended by the code, and then they came into force as part of the Companies Act 2013. And as you know, one entire chapter, that is chapter 2 of chapter 20, consisting of the provisions of 30 with regard to voluntary winding up, have completely been deleted from the 2013 Act and have been transported into section 59 of the code. But now let me just quickly, briefly tell you what remains in the code, what remains in the Act and what are the changes. So the provisions of the 2013 Act with regard to winding up as originally enacted are all to be found in chapter 20. Part 1 of chapter 20 consisting of sections 271 to 303 contain the provisions with regard to winding up by the tribunal, which earlier on would have been winding up by the court under the old Act. Part 2 of chapter 20 consisting of sections 304 to 323, which contain the provisions of voluntary winding up, as I said, have effectively now been, never came into force and have now become part of the INB code. Section 59 read with the Board of India, the INB Board of India Voluntary Liquidation Process Regulations. There are detailed regulations on how a voluntary winding up must be carried out. Part 4 consists of sections Part 3 consists of sections 324 to 365, which contains the common provisions with regard to what happens in a case of winding up. Now, the common provisions really would apply really to the first part alone. Part 4 consists of sections 359 to 365 and pertains to the appointment of official liquidators. The law with regard to liquidators has also changed because now, very soon, I think the liquidator attached to the Bombay High Court's office after the present lot of petitions are over will lose its relevance, because now you have liquidators appointed under the Act and you have the concept of private liquidators that have been also introduced. In certain cases you may have private liquidators appointed. Now, by section 255 of the code, this is read with the 11th schedule, the provisions of chapter 20 of the Companies Act were modified substantially, as I said, and the entire concept of winding up on account of unpaid debts was done away with. This question of what happened in the transition, if you are more interested in learning about it, it's covered in Justice Gupte's judgment in West Hills Realty, which Justice Dhanukar talked of. He's considered, because he was required to consider what happens with regard to the transition from the High Court, which petitions remain, which go, etc. And in that judgment, he has held that those petitions that continue to remain here, where service had not been affected, and continue to be governed by the 1956 Act. So what remains in the High Court will continue to be governed by the 1956 Act, the provisions of the 1956 Act. And those that are transferred to the NCLT will now really have to be converted to petitions of either in one of the two categories. There's a process for that and a notification that has been issued by the government in that regard. So in the context of the Companies Act, the only really the relevant regulations or the relevant sections which remain in the Companies Act pertain to those petitions now which remain here in the High Court, and those where you will go to the NCLT, but on some very, very limited grounds, where the NCLT will have power to wind up a company. So let me just touch on, as I said, using the 1956 Act as a reference point, let's see what has changed. First is the jurisdiction. The jurisdiction to entertain, hear and decide company petitions has now moved to the NCLT as a whole, except, as I said, for those that remained here pursuant to Justice Gupta's order. And pursuant to a government had issued rules for the transfer. Really, Justice Gupta's order interprets those rules. And under those rules, the company, some petitions remain here, and now everything else goes to the NCLT. So the first major change is that the jurisdiction goes away from the Bombay High Court. Justice Dhanuka says he's quite relieved. I'm not so sure I agree with him, but I must say there were happier days when we were able to have our company petitions here decided before the High Court judges. But as I said, the problem is today the NCLT, as Justice Dhanuka said, I'm sorry, I'm digressing for a moment, but I think it's relevant. Some of you are practicing there, some of you have come there and seen it. The whole problem is the intent is good. The idea to streamline, have specialized tribunals hearing specialized kinds of matters is conceptually great, except that if you don't have the infrastructure to do it, it just collapses, the whole idea collapses. And presently the problem is the NCLT is working very hard. They sit till 6 o'clock every evening, but they are infrastructurally completely quagmired. They are completely clogged. As most of you know, you can't even open the door when you go into the NCLT courtrooms. It's so jam-packed. They've been given such a heavy load of work to do that today you can't even get a hearing in a 397, 398 petition for love or money. So it's not in any way a comment on the NCLT or its ability on what it's doing. It's just overloaded with work, and therefore it's the only, in fact, the only thing that it's able to really hear today are matters under the I&B code because of the timelines. Now, to come back to what I was meant to address you on, the original section 271, which is the provision with regard to winding up, has been truncated and a petition is no longer maintainable at the instance of a creditor. That's the huge big change. That a creditor falling under the definition of a financial creditor and operational creditor now must approach the NCLT. Any other class of creditor has no remedy under this law. So you have to fall under one of these two classes as defined under the NCLT. Now, it may be argued, and there is a judgment of the NCLT, etc., that there may be another class of creditor, somebody who doesn't fall strictly under what would be an operational creditor and what would be a financial creditor. His remedy ultimately would be to file a suit because he would not be able to approach. So this is a huge change. Under the 1956 Act, any creditor of any description was entitled to come to court and file a petition, which no longer exists. The NCLT has in fact passed some orders on this and has in some cases not admitted a petition because it has held a person who was seeking some relief from as a flat purchaser of some amount that was payable by a builder as not to be an operational creditor. He's not falling under any of those definitions. And they have held in that context that operational creditor the definition is not inclusive. It doesn't say all persons who are not financial creditors but have money owing would be operational creditors. So there is a class of creditors who, because when I was thinking about it, I was just wondering who would you find in this class of creditors who doesn't fall under financial or operational. It by and large would cover most kinds of creditors, but there may be a couple of instances where people may slip through the gaps and have no remedy before the NCLT. So that person who, as Justice Dhanuka said, didn't want to wait in a queue by filing a suit for 20 and wait for 20 years and wanted to come to the High Court by way of a company petition because it was a quicker remedy, probably that door is closed for him. On the flip side, new grounds which did not find place in the 1956 Act have also been added in. A company that has acted against the interests of the sovereignty and integrity of India, the security of the state, or against public order, morality, etc., is liable to be wound up. This was not a ground that existed earlier on. So for instance, conceivably, if a company was set up to run an illegal gambling operation, it would be a ground on which it could conceivably be wound up by the High Court. There was not a ground on the early, and it goes to other aspects of sovereignty and integrity of India, security of the state, against public order, morality. Then, at the instance of the registrar, if it was found that a company was set up for a fraudulent purpose, that somebody set up maybe some chit fund company to con people into collecting money and doing an operation which was illegal, was covered by SEBI regulations but was unregulated, for which their permissions were not sought, something like that. So a company set up where the motive is fraudulent, the registrar may ask for that company to be wound up. And then there is also, companies can also be wound up if there's default in filing returns for 5 consecutive years, etc. Now, as I said, I don't know how many, as all of us, when we are practicing now if you have to go, even for this kind of petitions, we have to go to the tribunal. In actual fact, I don't know how many such petitions are going to be there or how many of us are going to be effectively appearing in these matters, which is why I said, to some extent, this has become, from a practitioner's point of view, a little academic. Then, some of the other grounds under 433, such as failure to file statutory return, failure to commence business, reduction in number of shareholders, etc., have been dropped from the amended section. Right. Then the power of the tribunal under section 273 is similar in most parts to the old 443. One important difference is that an order under 273 has to be made within 90 days from the date of presentation before appointing provisional. Now this is in keeping with the general trend of the code to have time limits for everything, to make all these matters where financial dues are outstanding time bound, so people don't feel that they can use the court system to delay paying back debt. Today, one of the biggest problems in India we've had at least for the last 20 years is people believe that they can borrow money, not pay back their debts and get away with it, and because of the fact that you are not able to get immediate or quick judicial redress. And even from a commercial standpoint, the way the party looks at it is, all right, I haven't paid the money, let him sue me, let him file a company petition. Ultimately, when 3-4 years later, when I offer to pay him back even the principal, he'll take it and go, because by then he's fighting for interest. He'll just take the principal and go. That's the mindset of a person who doesn't want to pay his debt. So to do away with that kind of situation, everything has become time bound, as has the provisions of the amended provisions of the Companies Act. Then section 274, which is the equivalent of the old section 439A, that is requirement to file statement of affairs. The first, I must also just point out that under the new act, there now provides very clearly that before a provisional liquidator is appointed, a company is required to be heard. There's a amendment in that section which requires a hearing before a provisional liquidator can be appointed. Then section 274, which as I said is equivalent to the old 439A, which is requirement to file statement of affairs, etc. The first requirement is prima facie case has to be made out. The company is only then required to file a statement of affairs. If the statement is not filed in the prescribed time, the company loses its right to file. Again, this is one of those the aspects of amendments with regard to making things time bound. So you can't come and you have a prescribed time within which you have to, it's like under section 34 of the Arbitration Act. You have a time limit within which you have to file a petition under 34, and it's a guillotine period. There's a 30-day extension which the court has a discretion, and then that's the end of the matter. So this is similar. You have to file your reply. A company can't keep matters hanging by delaying filing its reply. Then as regards the liquidator, section 275 covers the liquidator, which is similar to the old 448, 449. Now, as I said, the days of the court liquidator are numbered now. I'm sure he'll still be around for a few years because there are lots of petitions still pending. But after this, now we move to a regime of professional liquidators to be appointed from a panel maintained by the NCLT. The tribunal may also appoint an official liquidator under, if you see section 359, it provides for how official liquidators are appointed. So the government can appoint persons as official liquidators, but the tribunal has the power to appoint an official liquidator or to appoint a professional liquidator, which could be somebody like a chartered accountant or somebody who has some expertise in matters of handling companies' affairs. Then the liquidator also can be removed or replaced if justifiable cause is shown. If you look at section 276, you will find all the grounds on which a liquidator can be removed if he has misconducted himself in any way, he is not handling matters properly, he has not filed returns, etc. Then the effect of a winding up order, that is section 278 and 279, equivalent to the old 447, 446(1), say pretty much the same. That is, once a winding up order is passed, other legal proceedings, you have to take the permission of the tribunal, etc., etc. All of that, the liquidator takes over the affairs. Now, on the winding up of the company, the tribunal gets jurisdiction to try suits, claims against the company. Again, this is under section 280 in pretty much the same manner as it did under the old 446. So this part of the law, to a certain extent, remains unchanged. That the company, that all the powers that the High Court had was exercising as a company court, now the NCLT, with a few changes here and there, is by and large exercising all those same powers. Section 282 and 302 deal with the power of the liquidator and the tribunal to once winding up is underway. Again, these are similar to the powers under the 1956 Act. Tribunal has been given some very, very wide powers. And then coming to the repeal sections, that is 304 and 322, to 322. Now, on that already Mr. Dwarkadas in his presentation has addressed you to some extent, because those are the sections which have now really got incorporated into section 59 and go before the NCLT as part of the code, not as part of the act anymore. Now, what is important is, earlier on, the entire proceedings with regard to voluntary winding up were governed by a number of sections. All these have been incorporated into one single section, that is section 59, which sets out the entire procedure, which probably just makes it easier from the point of view of how, as a practitioner, or in reading the law and applying it. You don't have to run from section to section. Everything virtually is under 59, read with the rules that have been framed, regulations rather, that have been framed in this regard. I will quickly just tell you again the changes, the shifts. The provisions of 59 apply only to corporate persons, which means a company as defined under the Companies Act, a limited liability partnership as defined under the limited. So that is, I think, again on Mr. I'm going to try and, a lot of what I'm saying or have in my note to say to you is already been covered either by Mr. Dwarkadas or Justice Dhanuka. So I'm just going to skip through that portion, given the fact that we are running behind the clock, and I am going to just tell you what I have to say in addition to that. So again, it's the concept has been extended to limited liable partnerships, etc., and are not restricted to voluntary dissolution of companies any longer. Under the 1956 Act, a voluntary winding up of the company consisted of members' voluntary winding up and creditors' voluntary winding up. However, in the IBC, the regulation, there is no concept, as you know, of creditors' winding up. Same has been done away with. That's the other big change. Then under 59 of the IBC, a corporate person who intends to liquidate itself voluntarily and has not committed any default may institute voluntary winding up proceedings. The requirement of the company not committing default to initiate voluntary proceedings of liquidation has been added in the IBC and was not present under the 1956 Act. Then the company, under the 1956 Act, a director directors of the company which intend to voluntarily wound up are required to declare that if the company has any debts, then the company will pay the same within a period not exceeding 3 years from the date of commencement of winding up. The corresponding provision on the IBC doesn't, surprisingly, have laid down a time frame. That's a bit surprising given everything else. Then under the IBC, there is no requirement any longer for a company to call a meeting of its creditors, which is held to be held on the same day, on say next day, of the general meeting of the company, for the purposes of the resolution. The meeting of the creditors will be held. There is no power granted to the creditors of company under the provisions of the IBC. However, under the proviso to 59(3), where a company owes a debt to any person, then the creditors representing 2/3 in the value of the debt of the company shall approve the resolution passed by the company for voluntary winding up within 7 days from the resolution. Then again, the insolvency professional, as I said, could be an independent corporate person. Then there's an interesting provision in the IBC which doesn't find place would never found place under the Act. That is to decide whether a creditor has made an extortionate claim against the company. So if sometimes what happens, the company is in liquidation and people come and make claims which are absurdly high for amounts which otherwise they wouldn't be able to recover. So the tribunal is entitled to decide and find out if such claims are extortionate claims and decide whether or not they are required to be paid. Then time limits have been stipulated under the IBC and the regulations for purpose of undertaking various acts by the liquidator in the course of voluntary winding up. So this again, the liquidator is not entitled to continue the process of winding up as goes on now for years and years and years. Time limits have been imposed on the liquidator within which he is required to complete the process of winding up, and 12 months is the process from which he is supposed to endeavor to complete winding up from the date on which he started the process. So again, it's a time limit kind of requirement. Then I'll move to the provisions with regard to the procedure and provisions for winding up, that is sections 324 to 358. Again, I'm just going to highlight some of the differences. As far as the fraudulent preference under the old Act, the definition of what was a fraudulent preference has been changed a little, was whether it be regarded in insolvency proceedings against an individual if such transfer delivery was taken or done by him within 6 months before presentation of an insolvency petition on which an insolvent is adjudged insolvent. Now, instead, the test will be whether an act done or suffered by the company has the effect of putting the creditor guarantor in a better position if the company goes into liquidation, would be better than if he would have been not done or suffered by the company within 6 months of making the winding up petition. So the test of what is a fraudulent transfer prior for the purpose of winding up has changed a little. Then the remedy under the 2013 Act is that if the tribunal thinks that a person is satisfied that a person has attempted to get a fraudulent preference, it's entitled to declare the transaction invalid, a provision that was not there under the 1956 Act. Then, as regards prosecution of delinquent persons under the new Act, there is now a provision which said, the earlier law was that everyone had to take liquidator and every other person who is an officer or agent of the company would have to take steps to insure and prosecute the delinquent. Except for the delinquent himself. Now under the new Act, the 2013 Act, it requires even the delinquent to assist, that is the accused himself must assist in prosecution against him. Now it may be suggested that this is unconstitutional and would violate Article 23, and I have no doubt our President Mr. Sathe will one day address you on the constitutionality of that section, on whether you can have a provision of this kind at all. The next change is that the company liquidator is required to exercise powers subject to sanction. The 2013 Act requires that prior to passing an order and application by a creditor or contributory with respect to powers to be exercised by the company liquidator, the tribunal is required to provide the applicant, as I already told you, from being heard, under the 1956 Act, company liquidator was subject to the control of the court and now he's subject to the control of the tribunal. I mean, that goes without saying, I think. Under the 1956 Act, unpaid dividends, undistributed assets in hands of liquidator were to be paid to the public account of India and RBI in a similar account. They are now required to be put in a separate account of undistributed assets. The powers and functions exercisable by a court under the 56 Acts all stand transferred. The tribunal, that goes again without saying. So, in calculating the period of, now I'm just going to skip through what I think are the less relevant changes and move to the next topic. The official liquidator, what are the changes qua the official liquidator is that you have, as I said, you have an official liquidators who will be appointed by the central government. This is in contradistinction to the attachment of the office of the official liquidator to the High Court. The powers and functions of the liquidator in many ways remain the same. They get time bound in how they have to complete the process of winding up. They are given some additional powers with regard to ascertaining debts, matters with regard to fraudulent preferences, etc. But by and large, in many ways, conceptually, the role of the liquidator remains the same as he would under the 1956 Act. That takes me to the two miscellaneous provisions, which are subjects which I am required to address you on. The transition from the provision of SICA and the effect of the Insolvency Code on the recovery of debt due to Banks and Financial Institutions Act. Now, both these amendments were really made, they are really in a sense what you would call housekeeping amendments. Because of the fact that the entire jurisdiction of courts and matters with regard to Sikh industrial companies, etc., everything is being transferred to one specialized body dealing with company law, that is the NCLT. The first amendment, the first provision with regard to is to be found in section 252 with regard to SICA. 252 of the code really amends the provisions of the SICA Repeal Act, which under which the proceedings would then come to court. They now go there. So there's really nothing much more as far as the Sikh Industrial Companies Act is concerned. However, as far as the Securitization Act is concerned, the changes are more interesting, and in that the code now, the Insolvency and Bankruptcy Code, in view of its non-obstante clause, really would, if proceedings are filed and admitted in the tribunal, will have a direct effect on proceedings which have been initiated under the Surface Act. So may I just tell you those, because those I think are more relevant. This whole subject, by the way, just in case you want to have more reading on the subject or you want a more instructive, has been dealt with by the Supreme Court in the case of Alchemist Asset Reconstruction versus Hotel Gaudaras, and the Supreme Court holds that section 14 of the moratorium expressly includes proceedings before the DRT under the Surface Act, and also in the Supreme Court judgment of Innovative, which you've been hearing about all morning. So those two judgments would make instructive reading to really get a complete idea and picture of the law in this regard. So effectively, as a result of the provisions of the code, now the proceedings under the Surface Act, if somebody initiates proceedings under the code, would come to an end. The other interesting provision is that a secured creditor can give up his security, and if he gives up his security, he now stands second in line to receive amounts after the workman. So if he holds on to his security, whatever he gets out of his security perhaps will go to him, but if there's any amount which is unsecured, then he goes right to the bottom of the list. While on the other hand, if he is a secured creditor and he gives up his security, he will have the benefit of coming second in the list after workman. Then as far as the RDB Act is concerned, again, the changes the name of the Act. I think that's the most substantial change. and it changes. So the RDB Act is now called the Bankruptcy Act. Yes, Recovery at Debts and Bankruptcy Act. I'm grateful to my learned friend Mr. Thakkar, who is an expert on this subject. And again, it only makes what I call housekeeping amendments with regard to the jurisdiction of the DRT to try certain matters arising under the code and etc. There are no other changes. Also, the non-obstante clause in the recovery under the code will obviously have bearing on the proceedings under the RDB Act. This is in summary a summary of, as quick as I could, on the question of winding up and the miscellaneous provisions. I haven't been able to, and I apologize for that, as Justice Dhanuka and Mr. Dwarkadas have not been able to circulate a note. But I'm given to understand by Mr. Sathe that all your email addresses are with the Bar Association. So I will, within the course of this week, prepare a summary of this. It's actually quite lengthy, but which contains all this as a quick reference guide if any of you need it. And I'll have it emailed to you through the Bar Association. Thank you very much.
Thank you, Mr. Doctor. These aspects were certainly very relevant and important to understand the entire scheme of the Insolvency Code and the Bankruptcy Code and winding up provisions in India. We can have some quick questions, but one request, please do not ask questions on pending matters in court or tribunal. So, pending or to be filed, I would say. So, please feel free to ask your doubts on the code as such. Any questions, or are we all clear about this subject fully? That is called the success of a workshop. You have something? Yes, ma'am. Yeah, no.
Well, I think probably Justice Dhanuka would be in a better position to answer it from the point of view of a judge. But let me tell you what I understand from it from the point of view of a lawyer. When all these expressions are used, so many expressions are used in that, ultimately what my understanding of it is that it would ultimately be a matter of discretion of the court to see whether there is a real dispute or whether somebody is just creating a fallacious legal dispute in order to try and avoid paying his debts. That's my reading of all the expressions used by the Supreme Court. So yes, you may call it a bona fide dispute, you may not. According to me, it's not as high a test as bona fide, it's somewhere on a scale a little below that. But it's ultimately a matter of a discretion that every judge would have to exercise.
What Mr. Doctor effectively means is that if the learned judge wants to admit the petition, he's going to use one of these three words. Any other questions?
May I ask? Yeah. May I ask?
Yes, please.
Sorry. As Honorable Secretary put a caveat, so this is sort of regarding a judicial opinion on this point. Section 14(4) says that there is a self-declared date of completion or the termination of the order of moratorium. The words are, the order of moratorium shall have effect from such date of the order till the completion of corporate insolvency resolution process. Section 31(1)(a) says after the order of approval of the resolution plan, the order of moratorium passed under the section 14 would cease to have effect. So, should we consider that the corporate insolvency proceedings would end on 180th day or on the approval of the resolution plan? Because, as my Lord Justice Dhanuka also said, all the suits, arbitrations would be stayed in between. Parties may be interested on 180th day or 181st day to have some orders from the tribunal or somebody.
See, 31, the entire period of 180 days is from the date of commencement of the proceedings till the declaration, final declaration. So this approval of resolution plan is also part of the activity which has to be done within 180 days. But don't cite this as an authority before me.
No, that's why I said this would not constitute a ratio or...
This is not a precedent.
Yeah, precedent.
This is subject to hearing advocates for both the sides.
Yes, my lord. Indeed.
All right, one last question, ma'am. Then we shall.
As per the moratorium, there is a period of 180 days, but as per the provisions of 33, the resolution professional has the power to, on the basis of the creditors committee, to even put in, before the 180 days, close the resolution plan. So what my question is, suppose on the 100th day or the 130th day, there is a proper resolution plan, why should that be foreclosed before the 180 days? Why is that discretion given? That he may submit and the court may pass such orders even before the moratorium period, as in the full 180 days.
180 days is the upper limit.
So within that would be even within 80, 85, 90. So my question is that suppose on the 130th or 40th day, there is a possibility for reviving the company. Why should the debtor be deprived of that opportunity when there is actually an upper limit of 180 days provided?
If that sufficient material is available, if committee of creditors on the basis of material available in response to the order of moratorium, if they come to the conclusion that it is expressly not possible to revive this company, then decision can be taken even before expiry of 180 days. So 180 days is the upper limit, subject to further 90 days. It is not a right.
So would exactly, so then would the debtor be in a position to at least be heard before the NCLT before such an order is passed, or he'll be completely deprived of that?
Next time.
Does he have a right to at least be heard in case there is a better resolution or something which...
Final decision has to be taken by NCLT. After this report is placed before the NCLT by the IPR, resolution professional. After taking a decision by the 75% of the voting rights of the creditors, that report is placed before NCLT, and thereafter NCLT is to take a final decision within 180 days. So at that stage, of course, the debtors are to be heard.
Thank you so much.
All right, thank you so much. I'm sure I see some more hands, but I think we are short of time. So thank you so much, and on behalf of the Bombay Bar Association, I express our sincere gratitude to Justice Dhanuka, Mr. Dwarkadas and Mr. Doctor for sparing their valuable time on a Saturday morning to be with us. On behalf of the association, may I request Mr. Vinay Kanoria to please present a small memento to Justice Dhanuka. May I request Mr. Manik Kalyaniwala to present a small memento to Mr. Doctor. Thank you so much, sir. I would also like to thank all of you as usual for your overwhelming response and your enthusiasm. We have started the second season. We have already had the second workshop, and I think we'll continue this very soon. Thank you so much and have a good day.